All right, welcome back to the FITSNews studio for another edition of your Week in Review. We have got a ton to cover, folks. Big news in the Murdaugh murder saga. We talked last week about the defense's big motion for a new trial for convicted killer Alex Murdaugh. We're going to talk this week about the state's response, tackling head-on some allegations of jury tampering against Colleton County, South Carolina Clerk of Court Becky Hill. Not only, though, did the state respond, their response included an affidavit from Clerk Hill herself. We're going to dig into all of that and the details of those jury allegations and discuss whether Alex Murdaugh will get a new trial. On top of that, we're going to go into the issue of judicial selection. In South Carolina, this news outlet has talked often about the need to fix the way judges are chosen in South Carolina. I'm going to sit down with Dylan Nolan. We're going to detail exactly how that process works with some footage from the latest hearing of the panel that picks judges in the Palmetto State. Last but not least, we're going to talk about a South Carolina lawyer legislator who's landed in some trouble, the newest member of the state Senate facing some seismic allegations. I'm going to walk you through those and talk a little bit about our process as how we handle sensitive allegations like the ones facing South Carolina Senator-elect Deon Tedder. All this and more coming your way on the Week in Review. All right, so I'm here with our resident Murdaugh expert, our research director, Jen Wood. Another Murdaugh filing, Jen. This story just continues to unfold. We had pre-courtroom drama, we had courtroom drama, now post-courtroom drama as a possible prelude to more courtroom drama. I mean, is this story ever going to end?
At this point, I do not believe that it's going to end anytime soon.
It's like that never-ending story, right?
Right.
Yeah, I won't sing again. So here's the question. We're obviously dealing with a motion for a new trial.
Correct.
For Alex Murdaugh. This was filed in Colleton County. Mm-hmm. There's not been a hearing yet scheduled for this motion, but we had the defense's request for the new trial on the basis of jury tampering allegations. And this week, the state responded to that motion, very clearly coming down on the side of a battled Colleton Clerk of Court Becky Hill.
Yes, absolutely. The battle lines were drawn after their response, obviously. The response came in hot and heavy. There's 25 pages of actual, legal filings, and then the rest of it was affidavits from jurors, from Becky Hill, from court staff as well. And they said in their response, they do not believe that they believe the court should deny the motion for a new trial.
On the basis of?
On the basis of all of the affidavits that they provided, that Becky Hill said she did not do this, she did not do this. She didn't. It was basically, point by point.
Blow by blow.
Yes.
Yeah, first time Becky Hill on the record anyway denying it. Well, I guess she spoke briefly with Mike DeWitt from the Hampton County paper.
Yes.
Vaguely, generally denying the allegations, but in this affidavit, you're right, point by point. But let's walk through this a little bit. One of the things I noted that was interesting in this state filing, again, contesting Murdaugh's request for a new trial, basically saying that the judgment entered should stand, that the sentences imposed by Clifton Newman should stand, and we'll get to Judge Newman in a moment. But looking at this motion from the state, there was an interesting component of it, Jen, a little, I don't know if you call it a spreadsheet or a table, but there was this, and we'll put it up here on the screen so folks can take a look at it. We published it along with the excellent report you and Callie Lyons did on FITSNews.com. But it's presented by the state. It's a table of jurors basically breaking down a few things, what remarks they heard from Becky Hill, and whether they saw one-on-one chats with Becky Hill and jurors, and then the last question, did they have any other observations? And you go through this list, there's a few things on here that we're hearing may actually make the defense's case. Is that accurate?
Right. So juror number 254 said that she heard, or they heard, I can't remember if that's a female or a male, Becky Hill say, watch Murdaugh's body language. And juror 789 in 544 said they heard, generally pay attention, look at body language, and be observant.
729, I think. But still, the basically the same thing. So that's three jurors indicating on the state's recapitulation of their comments that they said the clerk told them to look at his body language.
Right. And, in Becky's affidavit, she denied everything, but I noticed she specifically did not bullet point deny that she told the jurors to watch his body language.
Very interesting.
Yeah.
So in the affidavit, the one thing that is particularly referenced here in this table is not referenced
Right.
in her affidavit.
Right.
Jill, let me ask this question. Why does this matter?
So I'm as a court official, what the interactions that the clerk of court has with the jury, it bears more weight. It bears more weight with the jurors, and the standard is it's different than if the jury was influenced by another outside source.
Because they're an official of the court.
Correct.
That's the argument.
Right. So the standard, if it was anybody else, would be, would it have changed the verdict? But since it is a court official, it is, could it have changed the verdict?
Okay, I want to rewind that a little bit because my understanding was that and the state makes this claim in its argument that it's a two-pronged test for this jury tampering allegation against Becky Hill to result in a new trial for Alex Murdaugh. Not only must it be proven that the tampering occurred, but that the tampering resulted in a verdict different than would have been reached absent the tampering. So it's not just did she allegedly tamper, it's did she allegedly tamper with success.
Right. So if you go and look at case law in the South Carolina Court of Appeals, the case that they're referencing is Holmes versus United States, where they said in this case there was the private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. When there has been such a communication, a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict.
Could not. So that's the could you're talking about.
Yep.
All right, so let me ask it this way. I don't expect this will happen. I don't expect that all 12 jurors put under oath in an evidentiary hearing, which we think is going to happen. We'll talk about that in just a second. But let's assume that an evidentiary hearing is scheduled to probe these allegations of jury tampering. Let's just assume, for the sake of argument, that all of the jurors who convicted Alex Murdaugh of the murder of his wife and the murder of his younger son, all of them say that either there was no tampering or whatever remarks we heard did not impact our decision. Shouldn't that be game over for the defense?
No.
You're arguing that based on this could standard, that even if they say that, he still gets a new trial?
Yeah, absolutely.
Well, let me ask it this way. So you are telling me that based on this table that the state put in this motion, outlining these three individuals who claimed that Becky Hill said to watch the man's body language, you're saying that's already the ball game for the defense?
And here's why. So here's the thing. So in the state's response, they asked for two things. They said they believe that the motion for a new trial should be dismissed. And if it is not, and an evidentiary hearing is held, they want to limit the questions asked of the jurors to 4 different questions. Was your verdict guilty on both charges, and is that still your verdict? Was your verdict based 100% on the testimony, evidence, and law presented at this trial? Was your verdict influenced in any manner by any communication with any of the bailiffs or any other person outside of the 12-member jury? Did you have any communication with any of the bailiffs or with a third party not part of the jury? And if so, please relay to the court what those communications were. They do not want to have an open questioning of these jurors. They want to limit what the jurors are answering.
And the state has made some arguments. I was reading this hearing. They talked about how this would have a chilling effect on the ability of juries to render verdicts in all cases, that who would sign up for jury duty if this
should
sort
have
of
a chilling effect on everybody in terms of the legal system. I think there needs to be an evidentiary hearing to clarify what happened. I mean, did Becky make these comments? Did she not? I mean, I know everybody's got opinions. I don't have all of the evidence. I need to hear what these jurors say under oath.
Well, we've been talking about this evidentiary hearing, and we're going to get into the question of who might hear that hearing here in just a second. But before we move on from this, the hypothetical we were speaking of earlier of all 12 jurors coming out and saying there was no tampering or there was no tampering which impacted our decision. We don't expect that to happen because you talked about battle lines being drawn earlier, Jen. There's clear battle lines being drawn based on the fact that there are certain people heavily invested in the outcome of this case representing these jurors. Eric Bland, for example, representing multiple Murdaugh jurors. Joe McCulloch, a very close ally of Dick Harpootlian, representing some of these jurors. So I don't think the jury's going to be singing from the same sheet of music, do you?
No, I do not. I do not. So what do you do? If some jurors say, yeah, that happened, some say, no, it didn't happen, to me, you have to err on the side of caution. Right?
Even with a notorious...
Do I think Alex is where he should be? Yeah, I really do. He should be in prison.
For the rest of his life?
For the rest of his life, yes, absolutely. But I also think a fair trial in front of an unbiased jury is fundamental to our criminal justice system. It's a fundamental part of our judicial system. And right now, I need to be, as a citizen, I need to know that that is what is happening, and I don't feel like I do.
Well, in this case, it's not just the jury tampering allegations. Obviously, Dick Harpootlian, Alec Murdaugh's lead attorney, has been making the case that this was a comedy of errors from the beginning.
Right.
He referred to SLED's mishandling of this key blood evidence, which basically is what convicted Murdaugh in the court of public opinion, at least. You know, the high-velocity impact spatter that turned out not to be quite what it was billed as. I mean, I think we can all agree that the state oversold that in the run-up to this big double homicide trial. But, Jen, let's talk a little bit now about, you just spoke very eloquently, I think, about the need for us to trust the process. Because I've seen a lot of commentary on social media, but one of the things I've seen on social media that has really, I guess, reinforced my faith in people's ability to think critically. I've seen a lot of folks point out that this is not about Alec Murdaugh or any other defendant, but it's, as you said, it's about a process that, think if it was you, think if it was one of your family members, think if there was a bunch of circumstantial evidence against you or one of your family members, but you knew in your heart you didn't do it. Now, I don't think that's the case here, but if we set a precedent regarding this process, it has implications for all of us. Let's talk now, though, a little bit about people being invested in this outcome. And I think one of the best points the defense has made as it relates to the investigation of these jury tampering allegations is that the people doing the investigating have a vested interest in the outcome, the State Law Enforcement Division.
Absolutely. I still cannot get over the fact that they are the ones doing the interviews and obtaining the affidavits from the jurors.
But not just SLED, is it? It's not just the investigation of the jury tampering allegations. It's the ultimate determination of their veracity and whether they rise to the level of warranting a new trial. And who right now, Jen, is responsible for making that decision?
Judge Newman.
America's judge.
Who I adore, who I think is a fabulous judge, who was the right choice for the judge in this case. Absolutely. I mean, do I like, everything about how he was appointed? No, but he did a great job. His temperament was great. He's so knowledgeable about the law. I thought he was perfect for that, but if we were to get an evidentiary, everybody's like, what do you think the chances are? What do you think? Yeah. Everything depends on if Judge Newman is presiding over this evidentiary hearing. I do not think that there is a very good chance that there's going to be a new trial.
Put a number on it.
If Judge Newman were presiding, it's like 0.
Okay.
I just don't.
I concur, by the way. But your rationale for that?
I just don't. I don't know. I mean, I think he can be unbiased and objective, but I don't know that he can on this. I don't know. It just feels off. And
the fact we have to question it kind of raises.
Right. And I was going to say the fact that it feels off is a problem.
Let me throw another name at you. It's been suggested one of the potential judges that could wind up hearing this in the event the Supreme Court were to determine that Judge Newman were either a fact witness to these tampering allegations or that he violated his obligation to remain unbiased. If they decide either of those things, the name of former Chief Justice Jean Toll has been tossed into the ring. But let's assume it's Toll. Let's assume another judge. You said 0% chance of a new trial if Newman's considering these matters. What do you think the percentage chance is of a new trial if Toll or some other judge is considering
I think it goes up quite a bit.
Well, put a number on it. I'll challenge you.
People are going to lose their minds when I say this, but I would say 70% right now.
Wow.
Yeah,
just based on this.
Yeah, but it depends on a lot of factors. You know, when they do the evidentiary hearing, if there's an evidentiary hearing, because that has not been decided, when they do it, are they going to limit it to these 4 questions that the state wants? Because words matter. What the jurors are asked and allowed to say under oath, that matters. And if they're asking very limited questions, it's going to close that door a little bit. So, I mean, it does depend on some factors, but yeah, I think it could be high because I'm seeing things in here. Nobody should be giving the jury any instructions about how they are viewing this case except for the judge. And for somebody that is not the judge to say, watch his body language.
Assuming that happened.
Assuming it happened is a problem.
Yeah. One of the comments we got from one of our members of our audience was that the only thing the clerk should have been saying to them was, what do you want for lunch?
Right.
Which,
and here's the thing I'd like to point out. We have not mentioned the egg juror once. One time. Mm-hmm. So, yeah, it might be a little bit of smoke and mirrors, but there is some stuff in the defense's motion that matters, and it makes sense. Yeah.
The egg juror, obviously, the one member of that panel who was sold on the defense's case. She did not believe Alec Murdaugh was guilty. She was not going to vote to convict him, and it was only her removal the morning of those closing arguments that led the way to that unanimous guilty verdict for Alec Murdaugh. Just a huge high-stakes decision. And again, like you say, that process, we've got to be able to trust it.
Right.
Not because of anything we may think about Alec Murdaugh, but again, trusting that process. And now, Jim, we've got to trust the process by which we determine whether the original process was fair.
Right, right. And yeah, I mean, you may never be in the position where you have a loved one who is facing criminal charges and you're in court and you're worried about a jury selection. But don't ever assume that. You never know. You never know that. Don't say that's never going to happen to you. So what are your odds on that?
You put me on the spot.
Oh, heck yeah.
I agree. Well, I agreed with you earlier. I think it's 0% for a new trial if Judge Newman is hearing these arguments. I think he's just too invested in the outcome, like everyone else. I mean, let's be honest. I mean, the Attorney General of the state's running for governor.
Right.
More than likely, this was a huge feather in his cap. Judge Newman went on the Today Show, became an international celebrity in the aftermath of this. I think a lot of folks are very invested in the outcome, but I do think Joe McCullough, let's give him a little credit. He did say the only thing any of us should be interested in is the integrity of the system, and I do believe in that. Your question on a new judge, whether I think that would result in a new trial, I'm at 50-50 right now. I think we do have to hear these the evidentiary hearing first, but I am 100% that hearing needs to be presided over by a judge that does not have any interest in the case, and as the defense laid out, is not a potential witness.
Right.
A lot to consider. Jim, let me ask you this as we sort of wind down our discussion of these latest developments in this case that, again, never seems to end. If we do have a new trial, if Alec Murdaugh stands trial for a second time, what do you see shaping up differently from the first trial? Differences in the approach?
Well, I think we're gonna have to talk about that financial evidence, prior bad acts, whether or not that is admissible. And you got to remember, if we do go into that is a huge if, but if we do go into a new trial, Alex's defense team, it's basically like watching a football game where the defense knows every play the offense is going to make. It's going to be it's not going to be the same. It's not going to be, I don't think it's going to be as crazy. But I mean, there's going to be a lot of things that determine, potential outcome, and that financial evidence is a big one, the admissibility of it.
You're right. And in fact, there's a story up on FITSNews earlier this week. Published a big post about some of the chess moves in the background as it relates to this financial evidence about how several high-ranking members of the South Carolina Judicial Branch have made it clear, not on the record yet, but made it clear, at least in private conversations, that they do not want to address any of the admissibility rulings that Judge Clifton Newman made in the Murdaugh trial regarding those previous financial crimes. In fact, some of them have said, I spoke with a public defender who indicated that if Newman's rulings in this case were sustained, that due process in South Carolina would cease to exist.
Yeah, my jaw dropped when we discussed that conversation.
Pretty bold.
I think he has a point.
Yeah.
It was a good point.
But the thinking there, of course, is that if this case were to be thrown back to the circuit based on the jury tampering allegations, that all of a sudden those admissibility problems no longer have to be dealt with by those higher courts.
And if they choose a new judge, it'll be interesting to see who they choose, having that in the back of your head.
Yeah, no pressure, right?
No pressure, none at all. But I mean, so now we're waiting on this because we do have a financial crimes trial coming up scheduled in Beaufort, November 27th. And
days away.
Yeah, the defense has asked the Supreme Court to stay that while this motion is considered, motion for a new trial. We have not heard back on that. I was surprised I thought we would hear back on that this week.
That's right. We've got 3 big items on the table. The Supreme Court has to decide whether to stall the Murdaugh proceedings, all Murdaugh proceedings, until they decide on Judge Newman. They've got to decide on Judge Newman. And then at some point, either Judge Newman or a new judge has to decide on the validity of these jury tampering allegations. So if you thought the Murdaugh saga was done, yeah, it's not. Not even close. And assuming all of these things go the way Jen Wood thinks, we could be looking at a second double homicide trial for Alec Murdaugh. We'll have to see how it shakes out. But Jen Wood, what a great conversation. The research you've done in this case, just amazing. And you want to shout out to one of the attorneys you spoke with on some of these admissibility matters. She was helpful. Was it Mandy Powers?
Oh, yeah, Mandy Powers Norell. Yes, you kept asking, the could and would in terms of court, jury tampering, and she, very clearly explained that. We had a conversation on the FITSNews YouTube channel about that. She's so smart, gives a very balanced opinion.
Absolutely. Be sure and check that out, folks. It isn't just our opinion. We go to experts that know exactly what they're talking about. And Jen, you're a Murdaugh expert extraordinaire, but going the extra mile to find out these exact words, because the words matter, the process matters. Jen Wood, excellent work. And we'll see where this case goes from here.
Thank you.
All right, so now we're going to back the lens away from the Murdaugh-specific judicial drama in South Carolina this week to a much broader issue, one that this media outlet has spent a ton of time addressing over the years. I'm referring, of course, to the problem of judicial leniency in the Palmetto State, and particularly judicial leniency doled out by powerful lawyer legislators who appoint the very judges whom they appear before. South Carolina, if you recall, one of only 2 states in the entire country where lawmakers pick the judges, but it's actually more incestuous, more insidious than that. There's actually a clique of lawyer legislators that controls the panel, which screens the judges for lawmakers to elect. So they get to basically rig the game before they vote on these candidates. It's an incredibly corrupt system, one which has produced terrible results over the year. And watching that system at work this week, Dylan Nolan, our producer, our journalist by your own right. We used to call you Director of Special Projects. I think you've outgrown that title, man.
It's still on the business card, but I'm doing a lot of stories these days.
You really are. And a great report. We've got it up here on FITSNews.com. Dylan went to the Judicial Merit Selection Commission is what they call it. But Dylan, as we've reported, merit doesn't always drive the discussion before this panel, does it?
Well, it drives the discussion because that's being recorded by a court reporter, but the decisions it might not always drive.
Well, walk us through a little bit of what you saw this week at this panel. I know there was one particular case that we've covered extensively that found its way into these proceedings. Tell us a little bit about that.
Yeah, so David Miller is a assistant solicitor, and he worked his way into our universe through prosecuting Bowen Turner, and many say not prosecuting him hard enough. If you're not familiar, Bowen Turner was thrice accused of raping teenage girls in a very short span of time. The last of those, actually happened while he was wearing a GPS ankle monitor, and he was represented by powerful state senators and also Senate Minority Leader Brad Hutto, one of the most powerful lawyer legislators. And although Hutto was not representing him when the case was disposed, he received an extremely lenient, by many observers' accounts, sentence plea deal, which will result in him coming back on the street on November 15th, so real soon.
Yeah, he'll be out here in a little bit. Inauspicious timing for Deputy Solicitor Miller as he attempts to become South Carolina's newest circuit court judge. Now, there were questions raised about the Bowen Turner case, and I know that you've got a clip here where one of the members of the panel, Pete Strom, who obviously a lot of our audience is familiar with Pete, but really goes after him a little bit. Dylan, walk us through this exchange.
Sure. First, I think let's just watch it.
Mr. Miller, I think I've known you since you clerked for Judge Peoples.
Yes, sir.
And you're better than this. You've always been a tough prosecutor. I'm looking back through your file and I see where 2 sheriffs have written you letters, and that's after all the stuff has been public. Strom Thurman Jr., former solicitor, wrote a letter recommending you. But, you have created an issue that's an embarrassment to our judiciary and our court system. People, and you're better than this. You had a state senator represent somebody who didn't do a good job communicating with the victims like you should. And there's obviously some temperament issues here. And I think we've talked about that before when you've run, you can have a little bit of a temper. And I think in your questions, you were asked about how you're going to address your temper.
Yes.
And, I was going to ask you what you would do different. You've answered a lot of that. But I want to tell you, I'm mad at you for the way this thing has happened, because you've embarrassed our system. And I don't know whether you're going to get voted out of this today. I don't know whether you'll get elected judge. But I'll tell you this, if temperament is a big deal with this commission,
Yes.
and if you become a judge and you have this issue going down the road, I can tell you every single person sitting around here, we will vote you out the next time you come up.
Understood.
And this will be on the record the next time you come up.
Yes, sir.
Thank you, Mr. Chairman.
So this was very interesting. In preparing to go attend this hearing, I had, of course, read the transcripts of Miller's previous appearances before this panel, and Pete Strom in years before had really positive things to say. And you can hear in this clip he talks about having known him for a long time. So, and by the way, that reputation is not just something that Strom held before this hearing, which I attended this week. In 2022, Miller was awarded the highest award that a solicitor can get from the South Carolina Solicitors Association. So he's somebody who's well regarded. He's brought more than 5,000 cases to a verdict. He's represented clients in death penalty cases, both for the state and for as a defense attorney, which is fairly rare. So he's somebody with a lot of experience, and certainly somebody that you would expect to be running for a circuit court seat. But as you could tell, he got absolutely dressed down there brutally and on the public record there by Strom for the way that the Bowen Turner case was disposed.
Well, let's talk about this. Obviously, some scathing criticism on the Bowen Turner matter, but there was another case involving this particular prosecutor, judicial candidate, that didn't get brought up. Let's walk us through a little bit of that, Dylan, what was not discussed at this hearing.
Yeah, I thought this was very telling. This is the Lopez case, and it's one of these cases. We of course a couple of months ago had a release from prison early, Gerard Price. This was something that made national headlines because he ran from the police. There was an FBI manhunt, and of course famous lawyer legislator, infamous, some would say, Todd Rutherford, who sits on the JMSC, who sits literally directly behind Pete Strom, was the attorney who secured that release. Well, Rutherford also worked with Miller to secure the release of Mr. Lopez, a similar situation where he was an informant for the South Carolina Department of Corrections. But I think it's important, before we delve into why he was released, to spend a little bit of time on what landed him in prison, because I think it will explain the severity of this situation. Mr. Lopez, some say, according to reports, it's not completely clear, but they think he was going to do a hit job and went to the wrong house, because he broke into this house. He starts shouting at the folks who lived in the house, demanding that somebody who doesn't live there come out. He starts threatening their lives, and he eventually drags the head of household, the father, out in front of the house and shoots him 8 times. Now, it's my understanding that he didn't die, but Mr. Lopez was very deservedly sentenced to 40 years in the South Carolina Department of Corrections. However, Representative Rutherford was so kind to the people of South Carolina as to secure his release 14 years early, because he reported an inappropriate sexual relationship between a guard and another inmate.
A lot of that going on behind bars in South Carolina.
Yeah, and that's certainly something that you can see. Brian Sterling over at the South Carolina Department of Corrections is certainly making a lot of noise about trying to address. But a big problem here is that this was all not on the public record, that the victims in this case were not notified, which is against the South Carolina Constitution. And the South Carolina Supreme Court, in the wake of the Gerard Price debacle, very clearly came down in the opinions that were issued and said that these cannot be, they're of course allowed to have confidential, secret meetings between prosecutors and judges and defense attorneys, because in these cases where people are informants, there needs to be protection, or you'll just never have informants, and the criminal justice system would be significantly hobbled. But certainly these whole proceedings cannot be hid from the public. And Miller admits on the record he didn't know if the victims were contacted, and the way that he saw it, even though he was facilitating this release as the prosecutor, as the representative of the prosecution from the state, he went on the record and said he wasn't really familiar with the details. He didn't read himself in. So, we talk about Miller's reputation with his colleagues. We talk about these cases which he's disposed of. He served in the Marine Corps. He's somebody who certainly has a history of public service, but that was really concerning. And what concerns me more than that specific case, because this is something that's happened and that now is in the public and is being addressed, is the fact that the JMSC clearly knew about this. There's no way. I mean, Rutherford was literally in the room, and yet it was not addressed. And that, to me, on a commission that's tasked with evaluating the ethics of the candidates which come before it, is a grave mistake.
Absolutely. We talked earlier in the first Murdoch segment, Dylan, about the need to trust the process. Think whatever you want to think about Alec Murdoch. Clearly, we made our thoughts on him known, not only for the thieving and the betrayals, but the graphic crimes that he's been convicted of, but the process by which we hold even people like him accountable has to be beyond reproach. And as we think about that, these are the people who are in charge of that process, these judges that we appoint. And if we can't trust the process by which they are appointed, I mean, that doesn't inspire a lot of confidence, does it?
A house built on sand.
Yep, absolutely. Well, let's talk a little bit about this moving forward, because obviously you're covering this hearing. We'll be back next week before the Judicial Merit Selection Commission for a big hearing involving a judge that's probably very familiar to our audience, Bentley Price. As we look at this moving forward, Dylan, obviously there's 2 tracks going here. There's the current system, which is reviewing these judges, and we're holding that process accountable, but there's also the effort to fix that system. We got a ton of laws out there, a ton of proposals. Walk us through the latest on the reform effort to either get rid of this commission or make it so that the lawyer legislators don't totally control the process.
Yeah, so I would like to point folks, we don't have the time in this segment to go into all of this detail, but if you want to know kind of how we got to this point, I published a piece, I believe on Tuesday of this week, earlier this week, which went into the history of how we got to this point in the judicial reform process. So if you want to learn about that, go to FITSNews.com, read that piece. But where we are right now is that there's a House ad hoc committee that's been put in place to draft legislation prior to the voting on these judges, because Senator Wes Clymer, said that he will not, and he will lead a filibuster in the Senate. He will not vote on any of these judicial nominees unless there is judicial reform. So there's now, from the upper chamber, pressure on the House to bring forward a bill. And that is a really good thing, because for years, House leadership, and by the way, a lot of folks in the Senate, have been digging their heels in, resisting. But this is an election year. There's the political capital. We've talked to multiple elected officials who are running, or know people who are running, who know that this is something that's really connecting with the electorate in South Carolina, probably because of all this attention that the Murdaugh case raised, put the endemic corruption in this state in the spotlight. But it seems as though this legislative session, there's going to be an attempt to address this. And on Tuesday, there's going to be an ad hoc committee meeting, and the agenda for this was just recently released. There are going to be some heavy hitters there. So FITSNews, we're certainly going to be bringing our cameras. We're going to be there on Tuesday, and then we're going to be there later for Bentley Price. So these are kind of the next steps here.
Absolutely. Well, Deon, a wonderful report. If you haven't read it yet, on FITSNews.com, a great report here on that judicial selection drama that unfolded this week. And I want to tell our audience, not only are we going to keep tabs on these judges, on their decisions regarding bond, regarding sentencing, but we're also going to keep tabs and hold accountable the politicians who are putting them in their positions. Because, folks, ultimately, that's who's responsible. You want justice in South Carolina, you got to start at the top, and that starts with holding these lawyer legislators accountable. Dylan, excellent work. Look forward to continuing to cover this next week as this debate ramps up once again at the State House. Serious allegations require serious reporting, serious investigation, serious vetting. Whatever's been said about me or my media outlet in years past, there's no doubt that that is exactly the kind of journalism that we are doing. It was on display this week in a case that raised a lot of eyebrows, sparked a lot of controversy and consternation. It involves some sexual assault allegations against the newest member of the South Carolina Senate. I'm referring, of course, to the big report that was filed on FITSNews.com earlier this week involving South Carolina Senator-elect Deon Tedder. Now, this story has a lot of components to it, and it was first brought to our attention several months ago, as a matter of fact. Now, again, a lot of folks would say that that's when we should have reported on it, because this man was standing for election before the South Carolina Senate, but that is not how the process works. Political timing doesn't impact how we report things. We report things based on when we believe there's a factual basis, an evidentiary basis, a reasonable belief that this is something that may have happened, something that has been investigated, something that is being investigated. And in the case of Deon Tedder, the straw that broke the camel's back came on the morning after his election, when we were finally provided with a response from the City of Columbia Police Department to a FOIA request we made for any and all incident reports involving Senator-elect Tedder. We were very specific in that request. His full name, his date of birth, his age. Wanted to make absolutely sure there were no errors in this case. Now, the incident report we were provided was almost completely redacted. In fact, we'll pull it up here. You can see every single bit of this narrative completely redacted. And in fact, Senator-elect Tedder's name was also redacted. And not only from this report, but it was redacted from a referral letter we received from the Fifth Circuit and an acceptance of that letter that we received from the Office of South Carolina Attorney General Alan Wilson, which, by the way, is the agency currently charged with helping investigate and prosecuting any charges that may be brought against Deon Tedder. Now, all of this began back on the early morning of April 27, 2022, in the aftermath of a House event, an event tied to Tedder's service as a member of the South Carolina House of Representatives. We don't have details, but we do know that in the immediate aftermath of an alleged assault in the early morning hours of April 27th, a victim reported a sexual assault allegedly perpetrated by then Representative Tedder, one which she then submitted to the collection of a rape kit to document what allegedly happened. And again, we reached out to everyone involved in this case. We've reached out to Senator-elect Tedder. We reached out to the attorney of his unnamed victim. We've reached out to the solicitor who referred the case. We've reached out to the Attorney General. We've reached out to the Columbia Police Department, which is investigating. Again, no one commenting on the ongoing investigation. But I found the fallout from this very interesting. Obviously, you publish a story like this involving any politician, people throw criticism back. They accuse all sort of things. If a politician is one race versus another, people will say racism. You have all this stuff come out. But the interesting thing in this, we got a lot of heat from Republicans who claimed that we deliberately held this story until after Deon Tedder had been elected. Well, once again, that's not the way that this works. As I mentioned earlier, we published the story when we got the FOIA response, which just happened to be the morning after his election down in Charleston County to fill a Senate seat vacated back in May of this year by former Senator Marlon Kimpson. Now, I also want to point something else out that we made clear in our story. I went to a number of sources at the South Carolina State House who know Senator-elect Tedder. All of them said that the allegations against him were totally inconsistent with what they know of his character. We put that in the story. And I also put something in the story that I think is incredibly important for everybody to remember, that even though Tedder has yet to be charged, even in the event he is charged, everybody is presumed innocent until proven guilty. We put that in all of our stories involving allegations, large or small, against public citizens or anyone, because that is a bedrock principle of our system of justice. So I want to say something. I'm very proud of the report that we filed on the allegations against Senator-elect Deon Tedder. I think our news outlet handled them professionally, impartially, factually, based on documents, based on trusted sources. And I also want to point out that as we exit this segment, as we continue to investigate the allegations against Senator-elect Tedder, that there's another part of the process that we're going to continue to investigate. As you've heard throughout this segment, whether our segment on the Murdochs that I did with Jen Wood or the segment particularly that I did with Dylan Nolan about South Carolina's judicial selection process and how corrupt it is, Deon Tedder has been very involved in that process. In fact, one of the judges that we called out very aggressively in the last segment, Bentley Price, well, Tedder was at the heart of a scandal involving some curious moves of his calendar to accommodate clients of Tedder and the late David Ayler, who was a very prominent attorney down in Charleston, an ally of Tedder's, somebody whose cell phone is currently in the hands of federal authorities up in Florence, South Carolina, as they investigate wide malfeasance in South Carolina's judicial branch of government. But that's not the story related to Tedder I'm talking about. I'm talking about the attorney who was reportedly representing him in the immediate aftermath of the charges that were filed against him. You want to know who that was? That's right, folks. Todd Rutherford. We'll have an update on that story in future episodes. But again, count on this news outlet not to pursue vendettas, not to pursue angles, but to pursue the truth, to pursue the facts. And I want to tell anybody, Republican or Democrat, black or white, lawmaker, non-lawmaker, you name it, I stand by every word of our reporting on those allegations. And again, that man is innocent until proven guilty, but we are not going to shy away from reporting credible facts based on documents, investigations, and our trusted network of sources. That is how this news outlet has advanced the cause of truth and justice in the Palmetto State. That's how we will continue to do it. So stay tuned for updates on that Deon Tedder case as it moves forward. All right, folks, that is a wrap for this week's edition of the Week in Review. I want to thank everybody once again for tuning in, subscribing on our YouTube channel. But I've got a request for you this week. This episode, I hope, has shown that our media outlet is committed to exposing injustice, committed to standing up for victims, for public safety, for holding the system in South Carolina that's created to protect you, to protect your families, holding that system accountable. It doesn't come easy, though, folks. We are a small outlet. We're going up against big competitors who are often pushing a counter-narrative, protecting that same system that we're fighting to expose. Would you help us? A subscription to FITSNews is only $8 a month. You can subscribe there on our page. We're putting the address up, but that helps us in our efforts to bring these cases to the attention of the public and to bring that public pressure to bear on those in charge for these atrocious outcomes. You want to fix South Carolina, you want to fix the state, you want to get some real justice for a change, help support our efforts by subscribing to FITSNews.com. Thanks, and we'll catch you next week on the Week in Review.